Welcome to our employment law update. Sorry, I'm just moving to the side a little bit so you can see me to the side of the slide that I've got showing on the screen there. Welcome to the first of our updates that we've done in a little while. So thank you very much for booking on and joining us. We're going to be going through all of the latest employment law news over the next hour, and there's quite a lot to get through. We're certainly going to be covering everything that I indicated that we would be in the agenda that was published on the booking. So we're going to be having a look at the latest equality news. We're going to be having a look at the latest holiday pay case, the Harper Trust and Brazil case. We're going to be having a look at transgender issues and the protections surrounding transgender and gender critical beliefs, and then a couple of other little bits and pieces as well, just to make sure that you're up to date with everything that is going on. So I will crack on because we have got quite a lot to get through, and hopefully everyone can hear everything that is going on okay. And if you do have any questions as we go through, there is a Q&A box that you can pop some questions into as we go through. So you can ask that. If I don't get around to answering them as we go through the session, then please don't worry, because I will provide an update when I send the slides around, because I'll send the slide deck around afterwards, and any questions that were asked during the session I'll make sure are answered in the email that I pop out to you. So let's have a look to see what is going on at the moment. So first of all, I just wanted to give you an update on a couple of reports, a couple of surveys which have been published, which I think are quite relevant to the approach that employers take to equality and diversity in the workplace. Now, this first report, this is a report that was published by Randstad, and it covers a survey of 6,000 people. And as you can see, the sort of headline data that we have got that's being reported in this study shows that 72% of women who were surveyed indicated that they had been subject to some form of inappropriate behaviour by male colleagues, which is, that's 3 in 4 women in the workplace that were reporting this, which is clearly a really rather depressing statistic, and is one that obviously from an employer's point of view exposes the employer to risk of sex discrimination and harassment claims. And it shows that we have still got real challenges out there that we need to address as employers in the way that we educate our employees about discrimination, and particularly in relation to inappropriate comments, which I must admit tend to be the issues which I see on a sort of daily basis, I'm afraid, in terms of the issues that get reported to me by my clients. And another depressing figure on the slide there, that only 18% of women surveyed have said that they've never experienced any form of gender discrimination at all. Now, just so that we're not focusing solely on gender discrimination, when we then have a look at racial discrimination, unfortunately, the statistics aren't necessarily hugely improved. Now, this is a different study. It's one that's undertaken by the Trades Union Congress. It does limit it in terms of time, because what we're looking at in terms of time here is we're only looking at people that reported incidents of a racial nature within the last 5 years, whereas the previous study didn't restrict the time period. But as you can see there, we've got 2 in 5, so 40% of employees from an ethnic minority background who are reporting that they've experienced racism at work within the past 5 years, whether that be through racist jokes, racist banter, the use of stereotypes, appearance-based comments, being bullied and harassed. All of these are issues that employees are reporting, and so clearly we've got still some way to go in making sure that our working environments are free of discrimination. Now, going on for further equality news, because we've got quite a bit of Equality News and reports, etc., that have been published lately. Now, the pregnancy and baby loss. So the CIPD, obviously Chartered Institute of Personnel and Development, they've conducted a study and they found that only a third of employers have a formal policy to support employees who have experienced pregnancy or baby loss. Now, I must admit, I was personally a little bit surprised that it was as high as a third, because I've come across very few employers that have a published formal policy in relation to this sort of in this area. And I'm not surprised that we've got only a quarter of employees that are receiving pay. So I don't find the survey a surprise. Now, of course, whether we should be doing more or not is a completely different matter. And obviously, the fact that the CIPD are now highlighting this study means that there is probably going to be a bit more of a push for employers to make provision in this area. Now, sort of connected into that, we've got the neonatal care leave and pay bill, which is now progressing through Parliament. Now, this is legislation that was proposed some 3 years ago now. You'll see there's a bit of a theme because there's been a bit of a release of the of a blockage in the progression of various pieces of legislation through the House of Commons. Neonatal care leave and pay bill is one of these. So what this piece of legislation is going to do is that it's going to provide for up to 12 weeks paid leave for parents, so that they can spend more time with their baby who, having been either born prematurely or sick, is then receiving neonatal care in hospital or any other agreed care setting. So it's going to be an entitlement that employees get from day one of work. So there's going to be no qualifying period for this entitlement, and it's going to apply to parents whose babies are admitted to hospital up to the age of 28 days and who have a continuous stay in hospital of 7 days or more. As I said, this is something that we were expecting to become legislation a little while ago, but it's been missing from the government's legislative agenda. So it's interesting to see that now it is making its way through Parliament and continue. As I said, I'm continuing this theme of a number of pieces of legislation that seem to have come back to life. One of those is this extension of protection in relation to redundancy and maternity leave. Now, I suspect you probably have, many of you will have become aware or are aware of the fact that when a woman is on maternity leave, that she is entitled to receive protection while if she is put at risk of redundancy. And when an employee is on maternity leave and she is at risk of redundancy, then she is entitled to be offered any suitable alternative employment and must be offered that suitable alternative employment in preference to anybody else. So the woman on maternity leave gets priority over anyone else because she is on maternity leave. Now, one of the things that can, or one of the unfortunate workarounds that some employers then take in response to that legislation is to simply wait until the woman returns from maternity leave back to work. And then, of course, that protection no longer applies, because what that then means is that then that employee, the woman who's returned from maternity leave, is simply treated exactly the same as everyone else. So if there is an alternative role that is available, she then no longer gets offered that in preference to anyone else. She has to go through exactly the same selection process as any other employee who is also at risk of redundancy. Now that protection is now going to be extended for a period of 6 months after the employee returns from maternity leave. So providing that additional additional period of protection. It's currently making its way through the House of Commons at the moment. The government have indicated that they are now supporting this legislation. So we should expect this to be coming into force probably sometime in 2023. There is a possibility it could be 2024, but obviously we will keep you informed of all developments as we go through. And another piece of legislation that has been hanging around for a while and has now also been given an indication by the government that they are going to support the bill as it now progresses through Parliament. So this is the Carers Leave Bill. Again, it was originally announced back in 2019 as part of a consultation. And what this is going to provide for is going to provide for 1 week's unpaid leave per year for any employees who are providing or arranging care. Now, that doesn't necessarily have to be for an elderly relative. I appreciate that I've used the picture of an elderly relative on the slide, but it could be for anyone that you are needing to provide care for. So that's something else that is progressing through Parliament. Again, we would be expecting 2023, in all likelihood, could be 2024. It can sometimes be a little bit difficult to predict quite when they're going to be implemented, but it does mean that these the pieces of legislation that we were expecting to come in quite some time ago are now working their way through. So, okay, so that's the sort of equality and to an extent the legislative update news. Now, holiday pay. Holiday pay. Well, we wouldn't have an update really without a holiday pay case, would we? It wouldn't be right. We've had so many of them over the last few years, and we have had another one. Now, this is only going to be relevant for employees who work unpredictable hours, because essentially what we've got, and I'll just put this on full screen so that you can see it, some of the detail. This case dealt with an employee who was on a permanent 0 hours contract. So she had irregular working hours. And as part of those irregular working hours, obviously, because she was a visiting music teacher, that sometimes she would be obviously working during term time, but even working during term time, then the hours might vary. One of the common approaches that employers used to have in relation to calculating holiday pay for those individuals was, as you can see from this calculation here on this slide, to pay holiday pay at 12.07% of earnings. And the maths associated with that are 52 weeks minus the 5.6 weeks of statutory holiday gives 46.4 weeks that you work during the course of the year. And then when you calculate that through, that then gives 12.07%. And thank you very much to everyone who's just confirmed you can hear me. So I'm relieved that I haven't pressed the mute button as I've been progressing through this. So thank you very much. She argued that she should have her holiday pay calculated, as you can see, by taking an average of her earnings over the previous 12 weeks, because this is when the legislation was still only looking at a 12-week period rather than what it is now, which is a 52-week period when you calculate holiday pay. And she referred to the government guidance that stated that that employers, particularly with reference to that second point there, that they should not apply this percentage method. Now, this percentage method actually originated from some ACAS guidance. So ACAS did actually, I sort of hesitate to use the word recommend as such, but they published it as one of the options that employers could use to calculate holiday pay. But then they removed that from their guidance. The government specifically came out and said that that employers should not use the percentage method, but there was no actual law which said that there was a specific problem with that. Now, when we actually work that through a worked example, we can then now see the effect of this. So this is for someone who is paid £200 a week, but some weeks they might work, some weeks they might not work. It means that if they then take a week's holiday, they should then be paid £200 a week for each of the weeks of holiday that they take. So we're not averaging it over a particular period. So even though you might earn £200 one week, and then in the next week you might earn nothing because you haven't worked, which gives an average earnings over those 2 weeks of £100. That's not what we're doing here. We are looking at the week where work is undertaken, and accordingly the holiday pay, £200 per week for 5.6 weeks, gives us a total of £1,120 in this example, which actually means the equivalent percentage is 22.4%, which is obviously significantly higher than the previously recommended percentage calculation of 12.07%. Now, I don't mean to necessarily confuse you or try to bombard you with lots of maths, but this is the reason why the 12.07% figure was used, because if you're using 12.07%, then you can see here that this would then give a holiday payment of £603.50. Now, the reason that this £603.50 is important is because if we then have a look at the full-time employee example, so a full-time employee who is then earning £1,120 worth of holiday pay, which is of course again £200 for the 5.6 weeks. That means that the full-time employee is receiving 12.07% of their pay as holiday pay, which if you are, I will go back a slide, which if you are then a part-time employee, or not a part-time employee, an employee with unpredictable working hours, who is getting paid 12.07%, then that payment is down at £603.50, which of course seems on the face of it entirely fair, because they're receiving exactly the same proportion of payment as holiday pay as the full-time employee. But then again, when we go back to the previous example, or how the Harper Trust and Brazil case has actually worked out, is that we're actually looking at paying £1,120, so the same amount of pay that the full-time employee gets, but the proportion obviously then increases significantly in this example to 22.4%, but obviously it varies depending upon the number of hours that somebody is working, which means that what we need to do, if we sort of cut to the chase of, well, what does all of that very confusing maths mean for us, Matt? Because all you've done is sort of show us that it's going to cost us a little bit more. What you need to do is, if you do have anyone within your workforce where you've provided in the employment contract or anywhere else in a policy for that matter, if you're providing that the payment, the calculation of holiday pay is being done on the basis of 12.07%, then you need to change it. You need to change the contractual provision. You need to change the way that you calculate it, because otherwise you're going to be in breach of this latest holiday pay case. So go back to your contractual documents, go back to the way that your payroll calculates holiday pay if you have employees who are working unpredictable hours. Now, transgender and gender critical beliefs. Now, this is a very topical area, of course. It is an area where there is quite a lot of conflict, shall we say, both within society generally, social media, but from a legal perspective, obviously what we've got to do as employers when we're looking at transgender and gender critical beliefs is, well, what approach should we be taking as an employer to these issues. Now, first of all, what I want to do is I want to have a look at the meaning of what a protected belief is. And this is set out in the case of Granger and Nicholson. So when we are looking at a protected belief, because of course what the Equality Act says is that there are a number of protected characteristics. Obviously there are 9 protected characteristics, and one of those protected characteristics is religion and belief. And so where we are then having a look at what a protected belief is, and I'm focusing very much here on gender critical beliefs, and whether having a gender critical belief, and we'll turn to the cases where these issues have been addressed in a moment, but where there is a gender critical belief, is that a protected belief under the Equality Act? And what the Equality Act says, as I said, in relation as set out in the Granger and Nicholson case, is that the belief must be genuinely held. It can't be an opinion or a viewpoint. It's got to be a proper cogent belief, weighty and substantial enough to have a level of cogency, seriousness, cohesion, and importance. And then the final point here, and the reason why this is underlined, because this is the bit that's been focused on in these cases, is that it must be worthy of respect in a democratic society and be not incompatible with human dignity and not conflict with the fundamental rights of others. So this is then where the courts have then begun grappling with, is the holding of a gender critical belief a protected belief or not? Is the fact that holding a gender critical belief, the fact that it is of course then going to be in conflict with individuals who are transgender, does that mean that it's protected, or does it mean that it's not protected? Now, we've had a few cases go through the courts, and many of you may have seen some of them reported in the press. Now, the most high profile one is the Forstater case, and one of the reasons why it's become such a high profile case is because Mrs. Forstater received a reasonable amount of online support from J.K. Rowling. Now, just to set out what Miss Forstater believes. So Miss Forstater believes that a person's sex is a material reality and that it should not and cannot be conflated with gender or gender identity. So it then follows that she believes that sex is immutable, so it's not a feeling or an identity, and that a trans woman is therefore not in reality a woman. And so that while a person can identify as a different sex, and other people may go along with that, that this does not mean that their sex actually changes. So that's her belief. Now, of course, it necessarily follows that the holding of that belief is then going to be naturally in conflict with the views and the beliefs that are held by transgender individuals. And what Miss Forstater did was that she published some tweets that stated this belief. And as a result of publishing these tweets, that it wasn't her employer, she was contracted to work for GD Europe, and her contract was coming up for renewal. And then as a result of the tweets that she placed online, GD Europe were uncomfortable with those tweets, uncomfortable with the views that she was expressing, and so therefore on that basis decided that they would not renew her contract, which is of course why we got in the situation of the claim being brought. Now, in then looking at that test, and when I say that test, if we just go back these two slides, the test at the bottom here in underline, whether the belief of being gender critical, that sex is immutable, that you essentially, if you are born a man, you remain a man, and if you're born a woman, then you remain a woman. Whether that belief can be worthy of respect in a democratic society and isn't incompatible with human dignity and does not conflict with the fundamental rights of others. So that's the test that then the courts had to apply. And so in a preliminary hearing, and at the initial preliminary hearing, then looking at that test, Miss Forstater lost, because the Employment Tribunal concluded that actually, because her view was offensive to others, that it could not be protected. She appealed that, went to the Employment Appeal Tribunal, and they disagreed with the approach of the Employment Tribunal. They said that her belief was protected. And what they've said is that, as you can see from this slide, is that they held that the belief, it only needs to satisfy a very modest threshold. And that threshold, in terms of it being incompatible with the beliefs of others, is that the threshold shouldn't be so high as to deprive minority beliefs of the protection that they're intended to have. But particularly, it should even allow for beliefs to be held and protected, even where those beliefs might offend others. So it need only be established that it does not have the effect of destroying the rights of others. So essentially, it means that individuals can still have protection under the Equality Act, even though the views that they hold might offend other people. Now, of course, that then becomes problematic for us, because, and when I say problematic for us, it becomes problematic for us as employers, because as an employer, then what do we do? Because if we've got an individual who has gender critical beliefs, and we've got an employee who is transgender, then clearly we have got a conflict there between those beliefs and those protections in law. And so therefore it could be that one employee is going to offend the other, whichever way around that might be. And then that, as an employer, leaves us potentially liable to claims of harassment. So how do we deal with that? And where are the lines drawn? Well, we do have another helpful case that then began to look at this, which is the case of Mackereth and the Department for Work and Pensions. Now, Dr. Mackereth was a Christian doctor, and his belief, which derived from his religion, was again that a person cannot change their sex or gender at will, and therefore, as a result of that, despite the fact that he was being asked by his employer, essentially the Department for Work and Pensions, he was being asked to address his patients by using the preferred pronoun of those patients. But he said that, well, I don't want to do that because that doesn't accord with my beliefs. I don't think that is right. So there was then a number of things that happened, and essentially what Dr. Mackereth claimed was that he was suspended and essentially marched out of his workplace because of his refusal to do this. Now, there are some factual issues that I won't go into in terms of the actual case itself. Essentially, the facts and the evidence that Dr. Mackereth was relying upon with regards to the way that he was actually treated by his employer didn't stand up to a significant degree of scrutiny. But what the court did go on to do is it then began to have a look at, well, how do individuals manifest their belief? And that's then when we get to it, because get to the crux of the case here, because what we've got to do, or what perhaps certainly I and a number of other people within this area would have been suggesting or advising to employers and to employees, is essentially where you've got this conflict is that you would just say to employee A, well, you don't you please don't say anything that's going to offend this person. And employee B, you'd say, please don't do anything or say anything that's going to offend this person. So essentially just sort of drawing a line in the sand and saying at work, whilst you're at work, just don't go anywhere near this topic, don't go anywhere near the subject, don't express your views in relation to it, because then you won't offend either person. That's a little bit too simplistic now, because we've got this whole balance of the right to freedom of expression under Article 9. And so to what extent can we tell people that they can't express their beliefs and express their views for fear of the fact that it might offend or upset anyone else? And that's therefore where it begins to become a little bit more problematic for us now than perhaps it did do before. So therefore, what we're doing is we're having a look at the way that people manifest their beliefs and the reasonableness of the way that we address the manifestation of those beliefs, i.e. the way that people express their beliefs. And so when the court then had a look at this Mackereth case, so they concluded that the employer had a legitimate aim, namely the delivery of service to patients. This wasn't just simply about two employees interacting with one another. We had the delivery of a service, a public service, and therefore the employer was entitled to find that there were particular sensitivities arising from face-to-face interactions between the doctors and the patients, and that the steps that they were taking were proportionate to achieve this aim. So with the Mackereth case, then the approach that the employer was taking to try to control the offence that might be caused by the doctor who held his belief about sex being immutable was perfectly fine. Now, this particular issue, the way that the belief is manifested or expressed, wasn't really dealt with in the Forstater case, but you can see that therefore we've got a very difficult balance that we've got to attain. And this is just a slide that sort of looks at some of the facts of the case, which, like I said, I don't intend to go into in a huge amount of detail. Suffice to say that the tribunal didn't conclude that that Dr. Mackereth was subjected to any detrimental treatment at all as a result of his belief. He wasn't interrogated as he had claimed. He wasn't suspended as he had claimed. He'd not been put under any pressure to renounce his beliefs as he had claimed. And so that's the conclusions that the tribunal came to in relation to that were obviously relevant to the overall judgment that they made. So those are the cases. I mean, there are a couple of other ones. There's a case involving a barrister, Mrs. Alison Bailey, and Stonewall, that also has a look at gender critical beliefs and the manifestation of those. But what I also wanted to do was also have a look at the other side of the equation, of the view. And this is the other difficulty that, of course, I'm sort of trying to explain in terms of the way that sometimes the employer can be a little bit like stuck in the middle of these issues, because it's got to address the balance of these rights in an appropriate way. Now, this claim, and this claim goes back a couple of years now, but this was one of the first claims of an individual who was identifying themselves as being gender fluid at the time, non-binary, and the protections that, of course, that individual has from harassment and discrimination. And I would certainly encourage you to, you can go on the Employment Tribunal Judgment database. I'd encourage you to go and have a look at this case, if for no other reason than to have it's a very easy a read, and when you read through the decision, you can see that, or certainly I can see that this is a sort of case that could happen in many many companies where perhaps the education of employees about gender fluidity, gender identity, non-binary gender and transgender perhaps might not be particularly sufficient to ensure that employees who work there aren't saying it or doing inappropriate things. That is then going to end up with the person who is transgender or gender fluid being offended. So in this instance, Mr. Taylor, I say Mr. Taylor, it was Mr. Taylor originally, then Mr. Taylor, then I identified as non-binary, and then later transitioned to be Miss Taylor by the time the case got to court. Whilst being an employee, she informed the manager, informed HR and the manager that they were non-binary. And essentially the way that the employer then dealt with it wasn't particularly great, and that's putting it mildly. None of the managers who were dealing with the employee had good knowledge of the employer's dignity at work policy. They were essentially completely reliant upon HR to tell them what to do and how to behave, and notwithstanding that, would then say some rather inappropriate comments by the manager informing her that she was not normal. She was told to use the disabled toilet, told not to dress in female clothes, and other rather unhelpful and offensive comments were also made by other employees. And so it's clearly harassment under Section 26 of the Equality Act. She then later resigns her employment from Jaguar Land Rover, and as a consequence receives compensation of £180,000. But most interestingly, other than the compensation, was the fact that the tribunal also ordered that the judgment must be read, considered and minuted by the board of Jaguar Land Rover, that an equality audit must be done, and must be done for the next 5 years and published to all employees, and also published to Miss Taylor as well. And so there were some really significant criticisms and consequences. But when we get down to the law in this area, it was the legal issues here were just straightforward harassment. And it's simply the fact that as employers, what we've got to do is we've got to ensure that we take the appropriate steps to ensure that our employees aren't saying and aren't doing things that are going to cause offence, whilst also balancing the rights. And this is where we've got the I was going to say difficulty, but the complexity around this issue, where there are also individuals who hold gender critical beliefs, which are also protected. So it's an area which I think we're going to have to grapple with an awful lot more over the coming months and over the next few years as well. So it's something to be very aware of, and I'd certainly encourage you to be having a think about the education of your employees in this area, and well, generally harassment as well, in relation to other protected characteristics. But this is an area where I think there is a need for education of our employees in a way that I would hope that in relation to perhaps race discrimination and sex discrimination, that we don't need education as such. We just need people to do as they know they should do in relation to harassment and those issues. But perhaps with transgender issues, there is a bit more education that needs to be done. I just wanted to take the opportunity to just let you know about some of the services that we can provide. Don't worry, I won't take very long on this because I've got plenty of other content that I need to get through. But I just wanted to ensure that you're aware of what services that we can provide. So we've got a number of employer support packages, whether that be the more straightforward basic compliance package, just to make sure your contracts and policies and procedures are all up to date and maintained, We've also got a couple of other ways in which you can interact with us, have our services. So you can either purchase time from us at a discounted rate, and you can then use that time for advice and training and employment tribunals should you ever get them, or you can have a fixed annual fee. It's certainly the most common way that we deal with our employer clients. So for your fixed annual fee, you can then get all of the advice that you need, regular Teams and Zoom calls with us to keep you up to date on everything. Can also include representation in the employment tribunal as well. So that's representation in the case, and also the advocacy in the tribunal hearings as well. We can also put some training into that support package as well. And as you can see, we've got a number of ways in which we can provide support to your employees with training. I mean, the education piece that I was just talking about there is on the right, about educating your employees on discrimination matters. And obviously we can do that through online training. We've got some e-learning packages as well. And also, of course, face-to-face training across a whole wide range of absence, performance and disciplinary matters, as well as equality and discrimination. So don't worry, I'm moving on now. So continuing a theme of discrimination, I will talk about something which isn't discrimination shortly, but as you can probably tell, that the discrimination, I think, is really one of the key areas of risk, and also it's the key sort of key changes that we're seeing both in terms of case law and also legislation. So the first case we're going to have a look at is in relation to shift patterns. Now this case is really just simply a reminder more than anything else, because what this case is reminding us of is the fact that if we are requiring our employees to work a pattern of work, and even though we might be requiring all of our employees to work a particular pattern of work, that if that pattern of work is going to put women at a disadvantage because of their childcare responsibilities that they have, then that is going to be indirect discrimination. What the Dobson case in particular emphasised and reasserted was that there is a childcare disparity. So you can see at the bottom of the slide there, the EAT confirms that childcare disparities still exist. What that means, what I mean by that, is the fact that women are more likely to have to shoulder the burden of childcare responsibility. And therefore, if we have a rule or a system or a working pattern in place that doesn't neatly fit with childcare. So, for example, with this one, a change of a shift pattern required Mrs. Dobson to work occasional weekends. Well, obviously, it's more difficult to get childcare on weekends because nurseries don't tend to be open at weekends. They tend to be only open on Monday to Friday. So therefore, if she can't get childcare, she can't work those weekends. And as a result of only not being able to work those weekends, if she's then subject to a detriment by her employer for not complying with the requirements in relation to the shift pattern, then that's going to be indirect discrimination. Okay, now on occasions we can run justification arguments, which then might mean that we can defend claims, but that is going to be very much on a case-by-case basis, and it depends upon what your justification is going to be. So always be aware that even if you're applying a rule very consistently, that if it has a disparate effect, mainly because of childcare issues, that is going to put women at a disadvantage, then we are going to need to be able to justify our approach or make adjustments for the women that requirement then affects. And the same is true. The Follows and Nationwide case is another example of it. So Mrs. Follows worked under a home working contract, but was then required to work in the office for 2 to 3 days a week. Now, Obviously, this is an issue that many employers are having to address now as they try to get people back into work from having worked from home during the COVID pandemic. Actually, this arrangement of home working predated the COVID pandemic, so it wasn't directly linked to the pandemic, but the issues still remain very consistent with employers who are trying to get employees back to work after the pandemic. But essentially, the issue that Mrs. Follows had was that then, because she had a disabled child and she was being required to come back into the office, that she could not do so because of her disabled child, and that therefore she was then subject to both to indirect discrimination as a result. And again, some statistics for you. So it's noted in the judgment that 58% of carers are female as opposed to 42% of men, and so therefore there is again a disproportionate effect. And so whilst as a society, I mean, obviously the disproportionate effect might be getting narrower, the gap in relation to the childcare responsibilities is narrowing, but what these latest cases, and when I say is narrowing between men and women, but what these cases have reasserted is the fact that the gap is still there, the disparate effect is still there. Now, something that isn't discrimination, thank goodness I hear you cry. So we're going to have a look at suspension. So some good old-fashioned misconduct type issues to get our teeth into. So this is all to do with some ACAS guidance that's been published, some new ACAS guidance that's been published in relation to suspension. Now, there have been a number of cases over recent years that have clearly made it a requirement on employees not to have knee-jerk reactions to suspensions, not to simply suspend because it might be a gross misconduct dismissal. And rather what we need to be doing is we need to be having a look about whether there is a need to suspend or not, and therefore working some justification around the suspension. Now, usually that's simply about the fact that, you know, we don't want the employee to be around other employees who may have witnessed things, or we don't want the employee to have access to systems where there is going to be some evidence. So usually it's regarding the protection of evidence. But this new ACAS guidance goes further than that. So what this ACAS guidance is saying is that employers should take care when they're suspending people. And certainly when you're suspending somebody, then we don't want to be doing it in such a potentially upsetting way as to marching them off the premises and so on and so forth. I mean, I wouldn't recommend you be doing that anyway, because it makes it, it would make it look as if your mind is already made up if you're acting in that way, and certainly implied terms of trust and confidence can be significantly affected by the way that you conduct yourself when suspending an employee. But also this goes further because it's looking at the mental health of an employee, both following the effect of the actual act of suspension itself, and then also the fact that they are then not being permitted to come to work. And so we need to be careful and sensitive about the way that we suspend people. But it then also goes further, and it's then suggesting actual alternatives. So what this means is that really we're going to be in a position where what you should be doing is actually having a look at these suggested alternatives and making sure that you are clear that if you are going to suspend, that those suggestive alternatives, such as changing hours of work, changing location of work, getting them to work with different customers or away from different customers, or ceasing access to particular systems or tools or specific tasks, that you will need to essentially have a look at that and rule those options out as part of your process, rather than just simply, as many employers still do at the moment, just come to the conclusion this is a potential gross misconduct, so therefore we are suspending. Now, it doesn't necessarily mean that you won't you won't still decide to suspend, but it's just that we should be having a consideration of these matters. So you need to, I would encourage you, I should say, rather than need to, but I would encourage you to consider these matters, to make a note of your considerations, and to keep that on file, to make sure that if we are ever challenged on it in the future, that then we can show the approach that we have taken. Now, this doesn't form part of the ACAS Code of Practice at this point of time. I'm sure that in due course there will be various cases where people will argue that that overall this has affected the fairness and potentially should be incorporated within the Code of Practice, but as things stand at the moment, it shouldn't affect levels of compensation in the event that you don't comply with this. But I would just strongly encourage you, given that it's not too onerous, it just requires you to turn your mind to these issues before you actually issue the notice of suspension. So I got you all excited then, getting into some sort of proper misconduct issues, and then I take a quick about turn and then tell you I'm going to talk to you about data protection, which I appreciate isn't necessarily the most exciting topic, but then you read the first line of this. So, plan to replace UK GDPR. Now, before you get too excited, you will notice the date on this slide. So it was on the 3rd of October that the government announced at its conference its plans to abolish GDPR. Now, that, of course, was under the government of Liz Truss. And, of course, plenty of things have changed since then. So this really is going to be a case of, well, let's just wait and see what happens. One of the reasons why the government has said that it plans to replace UK GDPR is, of course, because of Brexit. So therefore, we're not bound by necessarily in the same way to GDPR in the same way that we were when we first introduced it. The government is having a look at other data protection models that are used in Israel, Japan, South Korea, Canada, that the European Union have already identified as being satisfactory, because of course we need to be able to ensure that we can still do business with Europe and transfer data with Europe. So we must ensure that we've got an adequate system for data transfer. But yeah, we'll keep an eye on this to see whether GDPR is going to be replaced or not. I think the biggest thing for employers that I tend to come across is, of course, the subject access requests. And I know that also the government are having a look at subject access requests and perhaps whether there is going to be any limitation there. But again, I'll have to just simply keep you up to date of any potential progress in that area. There's nothing really of any note to report at this point, other than the fact that they have reported that they are going to have a look at it. Updated guidance from the Information Commissioner's Office is on the way. Now, again, going back to the implementation of GDPR, which now, of course, is a little while ago, the ICO haven't updated their guidance for employers since that time. So now they have published some draft guidance, which therefore is now going to be compliant with UK GDPR rather than the old UK data protection legislation. So again, we'll just have to keep an eye on this for when we get beyond the draft guidance stage and we get to the actual publication of the guidance itself in due course. And so that is a quick whistle stop tour of everything that is going on at the moment. So I can see that somebody has asked in the Q&A box that they missed the first half of the webinar. Will the recording be available? So yes, a recording is going to be available. I'll send everyone the link to a copy of the recording in due course. It will probably be tomorrow, if that's okay, because I probably won't get the recording ready this afternoon. So any of you who are having any difficulty, because I know there were a couple of comments about people who are having difficulty with sound. So if you had any difficulty with sound, also likewise, there will be a recording made available. A copy of the slides will be sent to you. I will make sure that you get a copy of the slide deck this afternoon. And of course, if there is ever anything that you want or you need from us in any questions, any follow-up questions from this seminar, for example, or anything else that you would want to talk to us about, whether that be in relation to any of the training that we can provide, any of the e-learning packages, or any of the legal advice that we can provide, then please do just get in touch with us. But that concludes the session, and I, for one, am very relieved that despite the amount of content that we had to get through today, that I've managed to conclude within the 1 hour session. So I'm going to give myself a little tick in the box for that one. But please do have an absolutely great rest of the day. I know we're near the end of the week, so have a great rest of the week and enjoy the weekend when it gets to us. And please do stay in touch. Keep an eye out for some future updates. I know this was a while since we've done the last one, but we'll be doing them a bit more regularly again. So look out for another event, probably around about January or February time. In the meantime, yeah, as I said, have a great day, have a great rest of the day, and I will see you all soon. Thanks very much. Bye, everyone.